Hi everybody, happy Tuesday. It is almost, it is the end of October, October 28th. Hope everybody's with the kids excited for trick or treat here. Today I was going to talk about a relatively recent statute here in the state of Ohio. Was just at court the other day on a committee that I'm on for the rule change, and the judge was actually talking about this and how she might put it into her court orders. So it was effective this year in March 20th. It is called Section 2903.216, illegal use of a tracking device or application. And this is something, frankly, that comes up a lot in family law cases. Allegations that one spouse has like a tile device or a AirTag in the other person's car and is following them around to stalk. And it's been really hard to prove because the answer usually is, well, I have it in my car because I had it in my car to see if my car was stolen, not because I'm trying to stalk my soon-to-be ex. So I think the Ohio Revised Code has sort of taken a stab at solving that problem. So it says, except as otherwise provided in Section D of this section, no person shall knowingly do any of the following: install a tracking device or tracking application on another person's property without the other person's consent, or cause a tracking device to track the position or movement of another person without the person's consent. If the person installed a tracking device or tracking application on another's property with the other person's consent and the other person subsequently revokes that consent, failed to remove or ensure the removal of the device or the application after the other person revokes the consent. And then it says, for the purposes of this section, if a person has given consent for another to install a tracking device or tracking application, it is presumed that the consenting person has revoked that consent if any of the following applies. The consenting person and the person to whom consent was given are lawfully married, and one of them files a complaint for divorce or a petition for dissolution of marriage from the other, not later than 72 hours after being served with a complaint for divorce or a petition for dissolution of marriage. The person to whom consent was given shall lawfully uninstall or discontinue use of the tracking device or tracking application. If the person to whom consent was given cannot lawfully uninstall or discontinue use of the tracking device or application, the person to whom consent was given shall notify the court in which the complaint for divorce was filed in writing. So that's pretty clear. Your consent ends when somebody files for divorce. So that should solve a lot of the problems that we have about whether or not that should remain on the vehicle. And the statute has a lot more in it. That's just kind of what's relevant to my line of work. And basically, it's a criminal offense. It lists whether it's a felony or a misdemeanor down at the bottom. I'm not a criminal lawyer, so I don't get into that too much. But the bottom line is, could be a criminal offense. So I would actually be all in favor of the Lake County Court adding this into the orders. When somebody files for divorce, there's always a court order that says, you can't move any money out of savings accounts, and you can't move any money, you can't cash out your retirement accounts or sell your house or whatever. So I think this would be a great thing to add in there because it is something that comes up a lot. I'm glad the Ohio Revised Code is actually on top of this. It's a newer problem, obviously, and so sometimes the court, the state, legislature is slow to get on top of things that are newer issues with these devices. But I think it's a great thing. Should calm down on a lot of problems, and hope everybody has a good week.